Okay, we might make a start because we've actually got a lot of information to provide to you today. So welcome everybody. I'm delighted you're able to join Professionals Australia today for our briefing on ending pay secrecy in workplaces. Before we start the session, I'd like to take this opportunity to acknowledge the traditional owners of all the land across Australia and pay my respects to elders past, present and emerging. I also want to extend my respect to all Aboriginal and Torres Strait Islander peoples, including anyone joining us today. I also want to highlight that Professionals Australia supports the Uluru Statement from the Heart, and that we also actively support the Yes campaign for a First Nations voice to Parliament. So as I mentioned before, delighted you can join us today to hear more about the very welcome IR reforms that were introduced into Parliament last year by the Albanese government and were subsequently passed. The union movement fought really hard and for a very long time to secure these laws. And we believe that they actually now have the potential to deliver better pay, better conditions, greater gender equality, and more secure jobs. Today's session is particularly important because it's all about the new rights that workers have that enable them to openly discuss their wages and put an end to the pay secrecy that previously existed in employment contracts. You're going to be hearing from two experts in this matter, Margaret Buchanan, who is our National Director of Industrial Strategy and Workplace Advice and Support, and Lyndall Ablett, who is also works in our Workplace Advice and Support area and who is our Principal Legal Officer. So today's session is going to be really important for you because you're going to learn about the new laws, and we're also the union movement as a whole is actually going to be considering how do we make sure these new laws actually achieve positive change in workplaces, deliver gender equality, enable you to get a pay increase and make collective bargaining more accessible for all workers. Pay secrecy was a really important issue for unions and workers, and it was something that was pursued in the legislation because members need to have the right to talk about their pay and their conditions and understand that this can actually then influence pay demands and pay increases. So this session will take you through what the new provisions are. And again, I suppose over time, there will be a number of cases that case law that is established around this particular issue, and Professionals Australia will keep members informed of any developments in this particular area. So thank you, everybody. And I'll now hand over to either Margaret or Lyndall to kick off today's session. Thank you.
Hello, everybody. I might start off. Margaret's doing the sharing of the screen today. So thank you very much, Margaret, for taking on the technological burden. I avoided that one. I always find these kind of strange because you're speaking to what feels like nobody, but it's actually more people than I would generally speak to. As Jill said, these are really important reforms that we have in place. It's really exciting. As an employment lawyer, I see contracts all the time that contain these pay secrecy clauses, and often I'm not sure that employees really understand what the impact of those pay secrecy clauses are and the detrimental impact that it has on their ability to seek fair remuneration and for things like gender equality and such things. It's the silence and the secrecy that enables these discrepancies in pay to continue. And so that's why we do think it's incredibly important. So one of the things that we wanted to ask people today is whether they're subject to pay secrecy obligations, because in your contracts of employment, it's not necessarily that clear. And so we have put in here what is pay secrecy. It's what it sort of sounds is it's when you're prevented from informing people what your pay is. And so that's why it's really important that we would ask everyone, make sure that they've got copies of their employment contracts so that you can know what they actually are, because you'll find that even if you don't think you are, you may find that you actually do have one may find one in your employment contract. As I said, we see these all the time. and they're often not worded in the way you would necessarily think they are. They don't necessarily just say you cannot tell anyone about your pay. Sometimes they do. But what we thought would be useful is just to start out is to give people an idea of some of the kinds of employment pay secrecy clauses that we do see. So we've put them up here in the slide. So remuneration and other employment conditions are considered confidential and must not be discussed with other employees. Another example is the terms and conditions of this employment offer, including those related to salary and remuneration items, are confidential and not to be disclosed to other employees. So they're two examples that contain pretty express wording regarding that. If we flip back one slide again to slide 4. And so you'll see we have some other examples here. And the first one being the terms of this agreement are confidential and must not be disclosed by the employee without the prior written consent of the company to any other person. Now, as you can see there, it doesn't actually say pay secrecy, but the entire offer, which will also include in respect of pay, which means that you are also prevented. So it's really important that you go have a look at your pay, go have a look at your contract to confirm whether you are currently subjected to one of these clauses. The reason that's really important is I'll get to that later on, but the other example we have here is pay information is private and confidential. The employee must not share or reveal information related to the employee's remuneration other than for the purposes of obtaining professional, legal or accounting advice as required by law. It's one of the things I think employers like to do is to sort of make you think, oh, talking about money, that's private. It can be, but it also, as I said, it encourages, it completely discourages bargaining power. And so what we'd like to ask everyone today in the poll is it your understanding that you are required to keep your pay secret? So we should have a poll up there now, and you'll be able to do that. If you don't know, that's fine, you don't have to vote, but if you do know, it would be great to get an idea of how many of you are subject to or think you are subject to pay secrecy. Just waiting to see if we can see some of the results. So about half of you think you are, and about half of you think you aren't. I think 53% no. I'd really encourage those 53% to go back and double check their contracts. Because, and as I said, we'll get to why it's important, but once you get out of this presentation, I'd really encourage you to go look through your files, ask your HR for a copy of your employment contract, because we'll get to why that's important. So thanks very much for that. We'll move on to the next slide, and I will throw over to Margaret.
Thanks very much, Lyndall. So I'm going to talk a little bit more in less the legal side and more the industrial reasons for why ending pay secrecy is important for members. And we do have strong evidence to indicate that pay secrecy contributes to the gender pay gap, but not only the gender pay gap, also the racial pay gap. And we know that there are other impacts on workers too. So, for example, an organisation through pay secrecy may in effect reduce what the wages being paid for a particular role is over time, that you can't see unless you've got access to that information. When I say that we've got strong evidence to indicate that pay secrecy is contributing to these, discriminatory-based reasons for pay gaps, is that Canada, UK and Denmark have all passed pay secrecy legislation and found that in particular, the gender pay gap is being reduced with the introduction of that legislation. Now, our legislation has got some limitations. It may be needed at some point for further amendment to get the full impact. And Linda will be touching on where some of the boundaries are about how the current legislation is framed and can be used. But getting back to the issue of, well, why is this important for you, both as an individual, as a member of your occupation, and a work colleague? So if you know what your workplace pay ranges are, and you also know what your relevant occupational and industry-based pay ranges tend to be, then obviously you have a level of confidence about the basis on which you make a claim for a pay increase. Otherwise, you are pretty much at the mercy of the employer, who you may come in quite confident about what you think you should be paid, because you know what your work value is, but they can say, oh, we don't pay anyone that here. No one's paid that above here. And you have to essentially accept that on their say-so. Now, there is information available on an occupational and industry level, but knowing your workplace pay is really important. There was just this past week or so, further legislation has been made to make even clearer what the gender pay gap is through the Workplace Gender Equality Agency and their reporting requirements. So we are going to see some movements on this. The other thing I wanted to mention, and this goes to pay information, which Linda will be talking about a bit more, but I wanted to mention it at this point. It's not only knowing what the base pay is, but what other financial-based benefits are that are available in your workplace. And I'll take an example like a car. You might be aware that some people in your workplace have access to a car. Unless you know the details of, well, do they contribute to that cost? If they do contribute to the cost, what is the employer paying in terms of expenses and all the rest? It's very difficult to get an assessment of, well, what is that benefit actually worth? And even if I don't want a car, I'd rather ride a bike or catch public transport. What does that mean in terms of what I could be asking for in my salary to take account of that? So I just wanted to kind of just draw those out a little bit before we get into the details a bit more. And I'm handing back to Lyndall now.
All right, now getting to the part that everybody loves, talking about legislation. I say that in jest, but I legitimately do enjoy it. So the Fair Work Legislation Amendment, Secure Jobs, Better Pay Act 2022, it inserts new provisions into the Fair Work Act. And you'd likely would have seen there was a lot of stuff about this act in the news. And so it's slowly sort of bringing in new rights throughout the year. And so what these rights are in respect of pay secrecy, it gives employees the right to disclose or not to disclose your remuneration to anyone. So you don't have to. We understand some people may not be comfortable doing that, but it gives you the right to. And so I could see in the questions there, someone said that they'd always ignored these pay secrecy clauses on principle, and whether that could get them into whether that could have gotten them into hot water. Yeah, it could have. If you have a pay secrecy clause and you breached it, that could have gotten you into hot water. You'd be breaching you're breaching the clause in the contract. And it comes down to, like most contracts, whether employers enforce it or not. But yeah, it does leave open the possibility of getting into hot water. What this clause gives you the ability to do that. Importantly, it also gives you the ability to disclose or not disclose terms and conditions of employment that are required to determine their pay. So this, for example, as Margaret talked about, could be comes to just sort of pay information. So hours of work is the example that's used, and that's a really good one because someone could have a rate of pay, but what are their hours of work? So what's their actual remuneration outcome that they are getting? If their hours of work, if they say, I get paid insert amount per week, but they're only doing 10 hours, that actually might be a lot compared to if they were doing 40 hours. And so it's that sort of information that's really important. Now, one of the joys of legislation is that words can mean multiple different things to multiple different people. And unfortunately, what that means is we're wading into new territory here. We don't have court determined outcomes on what will fall within this clause. That will be determined as things come to the courts, and the courts have to make determinations over what is considered something that falls within that section. So that's also important to remember. If we could just flip back to the other slide again, Margaret. Thank you. So we would encourage people to sort of, when they are talking about their pay at the moment, definitely talk about your, like, what, if you're able to, and we'll get to when these come into effect and who isn't covered by these new laws, but disclose your pay. But I do encourage people to be a little bit more careful over disclosing other conditions at the moment, whilst we wait for the law to catch up, for case law to catch up to this. The other really, really important thing that this law enables people to do is to ask other employees about their pay and that pay information, those terms and conditions. It is limited to employees, and I'll talk a little bit about that later in terms of traps. But so it is very important that when you're asking, if you do ask someone, that they are an employee. Contractors are not covered by this. So if you ask a contractor, you lose the protection of the Act, but it enables you to ask an employee. It enables employees to have that dialogue together to work out what each person is being paid, and to work out if they're being paid fairly, or whether someone else is doing the same job is getting paid far more than other people, which is the really exciting thing about these laws. Thanks, Margaret. We move on to the next one.
Sorry, it seems to be a bit stuck.
This page is not responding. That's what we always want to see during the middle of a presentation. Well, what I can sort of, I'll keep talking while this is, actually, I'll see if there's any questions I can answer while this is happening. Might be the best way to go about it.
Lyndall, I'm just having a look at a few of the questions that have been asked, so it would be, I think, great if you could answer some of them. So we're looking at questions here about people who are working in areas where there are pay grades, and so you don't know what grade someone is on. So you could still actually ask someone around what grade are you on, and you could ask them about their pay, because the issue becomes here is, you know, you're grading, not just your pay. So apparently in some workplaces there's secrecy around the grades as well.
Yeah, so in terms of working out, it all comes down to what someone's remuneration outcome is. So in terms of establishing what someone is being paid, you're allowed to ask them what their pay is. So even though there may be transparency over someone who's on this grade gets paid between this amount and this amount, you will be, as long as there's no, and that's, I'll get to the reasons why these won't, why some laws they won't apply to, but if you're not covered by a pay secrecy clause, yes, you can ask them about that, what their specific pay is, even though the grading may be open in terms of people who are paid this grade paid between this and this, but the law would apply, generally speaking, it will apply to you'll be protected in terms of asking employees what they pay. And I should say, you're allowed to ask, you're not entitled to an answer. So that is also something to note, just because employees have the right to not disclose as well. So you can ask these questions, but that doesn't mean you'll get an answer, is something that's also relevant to know. Now, what you all probably wanting to know is, when do these laws come into effect? When can you start using them?
And one of the questions there, Lyndall, is around if you're on if you've got a contract at the moment that has a pay secrecy provision in it, do the laws wipe that out, or do you need to have a new contract or vary your contract? So how does the new law fit with existing versus new contracts?
That is an absolutely fantastic question. And I don't know if you can see that we've got the presentation, we've got the slides back up now, and that leads perfectly into this next slide. So thank you very much for that question. So these new laws will apply to you right now if your current employment contract contains no pay secrecy clause. Now, I should say, if you entered into your current contract from 7th of December, that clause will have no effect. But if your if you entered into an employment contract before the 7th of December and it has a pay secrecy clause, you must abide by that pay secrecy clause. So these laws will, from the 7th of December, these laws came into effect, and they apply to people who have no existing pay secrecy clauses in their contracts. If you entered into a new contract from the 7th of December, and also any pay secrecy terms in awards or enterprise agreements have no effect and cannot be enforced from this, could not be enforced from the 7th of December. I'll go on to the next slide, and that'll give you some more context over who this doesn't cover. So, as I said, if you commenced employment before, and this should say December, sorry everybody. If you commenced employment before 7th of December 2023 and your employment contract contains a pay secrecy clause, the new laws will not apply to you until, and here's the thing, until your new employment contract is varied. Now, under the legislation, it doesn't say, it just says varied. So any kind of variation should mean that your employment is covered. But in terms of what is a variation, your contract usually will contain some kind of process. There'll be a clause in there most likely that sets out the process for variation of a contract. But if you were going to rely upon these laws and you were going to rely on the fact that your contract has been varied, you would want to make sure that you have an agreed variation in writing, signed by both parties. That you'll check your contract to see what your contract requires in terms of a variation and follow that. But generally speaking, a variation is going to be, it's going to require offer acceptance, and it's going to require an agreement in writing between you and your employer to ensure that the contract has been validly varied. Until the contract is varied, you must comply with the pay secrecy clause in your contract. Now, Margaret will talk about some of the other ways that you can use these in terms of for your individual power and stuff, and even if you aren't able to access these new laws. But it's just very important, and we want to make it very, very clear to people, because you won't be protected by these laws if you breach your pay secrecy clause in your contract where you entered into that before the 7th of December.
Can I just ask, I think someone's made a really good point here, one of our participants, around the broader confidentiality clauses in agreements, in employment agreements, which is about you won't divulge to any person, business or corporation any information about the affairs of this company. So with the pay secrecy clauses, mean that you can talk about pay, but if this other provision around confidentiality is in your agreement, does that then stop you from speaking about pay secrecy?
Yeah, that's a really good question, and it's really going to depend upon the exact wording of your contract. It's really hard to give a sort of general answer. So there may be, if you entered into the contract now, like from now, say you went into a new employment contract and it contained confidentiality stuff, if there was an argument to say that that covered pay secrecy, it just wouldn't apply. So that you would be able to freely speak about pay. Where it is going to be a bit tricky is some of these previous contracts, and where to consider whether how broad is it, and whether it actually will cover, whether it is considered to cover pay, and it's going to come down to pure contract interpretation and the interpretation of the contract. And look, that might be an area that we wait to see some legal case law developments in.
Thanks, Lyndall. Sorry, Margaret, I'll hand over to you.
So just before we leave that, just to clarify, Lyndall, I think it is clear that the removal of pay secrecy only applies to contracts from 7 December and onwards. So if you had pay secrecy clauses in any former employment, that had post-employment continuance, that still applies as well. Okay, so let's just talk a little bit about, well, how can we start to use these laws? And some of it is about awareness. Let's be honest, that legislation, things can get forgotten about that it's there. And that's one of the purposes of today, is to make sure that our members are aware, but also know what your rights are in relation to this. And given that there are some boundaries around whether you can or can't. So knowing whether you have the right to ask others and to answer questions about your pay if asked is the first starting point. Even if, though, you're in a situation where your contract was prior to 7 December, it contains pay secrecy, there's still nothing stopping you from supporting the concept of pay transparency in discussions with others. And of course, if there were a collective agreement made that addressed pay secrecy, that would have the effect of overriding whatever was in your contract as well. So I just wanted to mention that, look, there is that element where collective agreements can have an immediate transformative impact on rights at work. And also, obviously, if you have got the right to discuss your pay, then actually use it so that you are better informed for going into pay negotiations. Now, using it on the collective level. So one way to bring pay transparency, if you are in a workplace that's currently using employment contracts, is to start thinking about, well, do we want to have a collective agreement? Pay transparency generally is one of the top reasons for why people like to have agreements. And I think I noticed that there was a comment about the public sector and about salaries being advertised upfront in job ads and so on. So the effect of pay secrecy is that often, even when you apply for a job in the private sector, the practice is that the salary is not advertised. And that is one of the things that I think we will start to see starts to change, particularly as these new rights become better known and people want to express, to have that pay transparency. And I go back to a class that I was in a couple of years ago that was mainly composed of people in HR, but it had some people from unions like myself that were there. And one of the things that was asked about, look, how do you get pay rises and make sure remuneration is fair? And coming from that group of HR people, what they said was people need to know what others in the workplace are getting. So they're the people that know, they're the people that have that insight to what is going on in a workplace. So that getting that transparency, their view is that it's going to make a difference because people will know. Now, we do have some collective agreements that have got salary provisions which effectively only state what the minimum pay rate will be for a classification level, or it may have where it's got a range, depending on how wide the range is. I think these are things that we would want to start including in our bargaining around claims, about whether we want greater clarity about, so why would someone be at the top end of the range compared to someone who's at the lower end? Does the lower end really just, and this is often the case with collective agreements, as people will know, just mean that's where the starting point is, and is that starting point where it really should be? We also have some agreements, and one of our members got in touch with us just prior to today to say, look, I'm not sure whether I'm covered by my agreement or not. There's a clause in the agreement that does apply to some people in my position. And so if that agreement is varied, would that be a variation of my contract? Very complex legal questions arising from that question. In many cases where we have collective agreements and we've got senior employees who are covered under that agreement, but they've got a contract that also regulates some of their conditions, and if some of those conditions related to maintaining pay secrecy, I don't think we need to wait for a variation in that case. I would be recommending that we, as a union, approach the organisation to discuss, look, you're out of sync now with what's happening with pay secrecy. Under the agreement, you wouldn't be able to maintain this. We think that this is something, we need to sort out with you now and try to get addressed. And that's the first thing you do when something like this comes up, is try to talk to the employer to see if they will agree to retract pay secrecy clauses in their contracts. That's where we've got established relations, such as a collective agreement is. So I think those contracts, we will need to review them and consider whether discussions, and I'll just mention a couple of names of the organisations I'm thinking to for those who are in the audience today. So I think Sydney Water is an example. Transgrid may also be another example where we need to look at what the actual terms of the contracts are to see if there's any pay secrecy provisions that we need to be discussing with the employer. Okay, back to Lyndall.
Now, one of the things that I think is particularly important for you as employees to know is, well, just because these things are in law and that says that you can do it, what's going to stop my employer taking action against me? Now, what we've got included in the Fair Work Act is a protection against things called adverse action. So adverse action is things like where your employer injures you in your employment. So that could be changing your days, giving you less hours, terminating your employment is also considered adverse action. There is a variety of things that can fall into that. And you are protected against that where you access these laws. So if you ask a fellow employee what they are paid and your employer finds out, and then they tell you, you've been asking employees what you've been paid, you're no longer getting overtime shifts on a Sunday, or you're no longer that's it, we're terminating your employment, that would be adverse action, and that is covered by the Fair Work Act, and that is the kind of thing that this protects against. Consequences for an employer taking adverse action is that you can take them to, you can go to the Fair Work Commission or you can go to court, and they can face civil penalties. A civil penalty unit is a penalty unit currently sitting at about $275. And when you work out what that would ultimately mean for an individual, it's about 16,000. Let me just I pulled the exact figure up here so that I could do it. So it's about 16,500 for an individual person who would be held when they're held liable, and $82,500 for your employer if they take adverse action against you. And that would be the kind of thing that we would ask you to directly come to us and we could help assist you with. The idea is that that doesn't happen and that this is there as a disincentive for employers doing that. But I think it's important for you to know what protections exist in the Act. Additionally, there are civil penalties applicable if an employer if an employer enters into a contract with pay secrecy clauses. Now, at the moment, that's not enforced, but from June this year, that will come into force. That will be applicable. So if you get, if an employer enters into a contract with you and you go, oh, hang on, there's a pay secrecy clause in there, that is not allowed. It is against the law. And once again, an employer can be taken to court and be subjected to civil penalties. So once again, that's the exact kind of thing we'd encourage you to come to us so that we can look at that with you and see whether we think that this is something that needs to go to court, whether there's something we can do to fix this. But That's really important that you're aware of the protections. If you have any concerns about anything in terms of whether something is going to be covered by if something's going to fall within, asking about pay, whether it falls within that sort of broader terms and conditions or pay information, as Margaret said, that's another thing. Contact us. That's what we're here for. We want to encourage transparency. It's it's one of the things I am most passionate about, and one of the things I was most excited to see in this legislation because of our union members, because I see these clauses in these contracts every day and I see the impact that it can have. And so I really encourage you to come to us to see if we can help you make use of these laws, because that's what we want. We want people being out there able to talk about it, being able to talk about their pay and negotiating better outcomes and fairer outcomes, most importantly.
Lyndall, I'm just wanting to know whether you and Margaret are happy to field some more questions now, or are there a few more slides that you'd like to take us through before we get to some additional questions?
I think I think there's a couple more slides we might go through before we get to questions.
No worries, thank you.
That's okay.
So please be assured, everyone, we're going to try and get through as many of these questions as possible. And for those that we can't get through today, we will collate them and provide some responses that will be available to you after the session. I think we'd be also happy to share the slide pack. So we'll answer the questions and provide the slide pack as well. So please be patient with us as we go through the rest of the presentation. Thank you.
I promise there's not much more to go, but this is a pretty crucial one. So it's the key things to be aware of. Now, so what we've spoken about earlier, it's crucial that when asking for someone's pay or conditions to check if they're an employee, you'll be not able to ask if they're a contractor. Now, what I should say is though, just because they're not an employee in the same organisation or have the same employer as you, that doesn't mean you can't ask them. So if you have a labour hire worker, for example, who is an employee working alongside you, you can ask them. If they are an employee, you are able to ask. You can't ask if someone is an independent contractor if they are working for themselves. Now that might be tricky, but it's one of those things that I really think is important that you try and establish with the person before you ask it, because we want you to be protected. But I should say it doesn't just extend to employees of your workplace or employees who share the same employer as you. It is broader than that, so that is important to know as well. And that goes the same with disclosing. It's to anyone. You don't just have to, you can disclose to other people who aren't employees as well. Your disclosures are to anybody, which is really important to know. So you should feel comfortable disclosing to your union. Now, terms and conditions can only be disclosed or asked about when they are reasonably necessary to work out someone's pay. So not all terms and conditions are protected. So it's really important to know that not everything to do with someone's employment relationship will be protected by this. It's only in relation to remuneration outcomes. And as I said, we will get more information about what that means as the case law develops. If you do find yourself in any hot water in respect of this, please do come to us and we will do our best to assist you. But I would tread lightly when it comes to these particular clauses that ask about hours of work and stuff. That's very clear. But at the moment, just wanting to be very frank with everybody, we just don't know yet what the court is going to be considered reasonably necessary. There is no guidance on that is in, and even when there is guidance, the ultimate guidance is from the court. And so once we have some precedent, we can give you that guidance, and we will. As soon as there is precedent, we will share that information, because as I said, our aim is to make this is to ensure everyone's getting fair remuneration outcomes. And that only comes with transparency. And so, and as soon as we have the ability to increase your ability to seek transparency, we will. And once again, just a reminder, if your existing employment contract has a pay secrecy clause and it has not been varied, you are not covered. If you want to know if your contract has been varied or if you're unsure about it, that is definitely something that you can come to us and seek advice about, and we can work through that with you. But as I said, variations, check your contract and see if it has a variation, it has a clause in there that talks about variation, because that'll be the first indication of how to go about getting it varied and the appropriate process to go through.
So just to be clear, Lyndall, the variation doesn't have to be about pay secrecy, does it?
No, that's what it doesn't. And I think it's one of those things where generally laws are not meant to apply retrospectively. They like things to like the general view is it's not fair to change a law and then have people who went along on their merry little lives be subject to something that is now unlawful, then it was completely lawful when they entered into it. That's the general idea. But I think in a way to try and stop these pay secrecy clauses from living forever and ever and ever, they've put in this nice little thing where it says variation. It doesn't say the pay secrecy clause has been varied, it's contract variation. So it could be a fairly minor variation. It's when it's varied, that's when these new laws will now continue to apply, So if you're unsure about whether your contract has been varied, look at what your contract says a variation will be and how it has to be done. But as I said, you're more than welcome to come contact us. Jill.
Just on that variation, someone has actually asked a really interesting question about what constitutes a contract variation. So in some workplaces, obviously, it's almost impossible to get a contract variation. What if your terms and conditions somehow change? So, your working hours change from what's in the contract, or there's a change in some sort of the flexibility provisions. Does that constitute a contract variation and then enable you to ask about pay? So that's one for case law as well, we think.
Well, no, that's more of a depends on the contract. So and as much as I dislike giving this answer to people, like once a lawyer, always a lawyer, it's going to depend on the particular circumstances. And so that will depend upon what's in your contract. And then it's going to depend upon the particular circumstances that you're talking about as to whether something constitutes a variation. Generally, but my general view, as a general best practice, if you're going to rely on these laws and you're relying on the variation, get something in writing. The way these things will come into effect is someone will accidentally do it and then an employer will argue that there hadn't been a variation and they'll have to go to court, and that's where we'll get some law on it. I'd rather that it doesn't have to be one of our members that goes through that, because going to court is not a nice thing. But so what would be better is if we can get some variations clearly done by agreement in writing. And as you said, they don't have to be about the pay secrecy. It can be any variation. So if your employer, so have it and employers may offer you variations, they may not, but also we can think about, and this might be something to think about in terms of, as Margaret said, once employers are out of step with these new laws, if they're still enforcing pay secrecy clauses, look, it might be something that come to union. It might be something that you can think about raising, going, okay, well, are people going to go to it? The employer is going to lose people if they're not able to talk about their pay. That's another condition that these employees don't have here that other employees will, especially when new employees come into the business. You're going to have, if they try and get them to enter pay secrecy clauses, those clauses won't be valid, and it's illegal for them to do that. So then you're going to have people on differing agreements. So there will become a point, hopefully, where it becomes not feasible for employers to rely upon these older ones, and they will want to get these contracts varied so that and enable people to have protection of the laws. But yeah, it's a complex question about whether something's been varied, and unfortunately it's really dependent upon what's in the contract and the particular facts and circumstances. And I'm sorry for giving that answer, because I hate it every time I ask a question and someone gives me that back, but that's the unfortunate reality.
So have we got another slide yet, or are we nearly finished? Because I've got there's a stack of questions.
So I just wanted to just remind people, because the issue of negotiations has come up a fair bit in the discussion, in what we're presenting. And I just wanted to remind people that, PA has our remuneration pay surveys. There is we do some presentations on doing pay negotiations, and we might want to revamp that given this is happening. With Lyndall's area does contract reviews. We do a lot of contract reviews. Fingers crossed we're the first union to run a case against an employer that they're trying to do pay secrecy. after 7th of December, and they shouldn't. And there's obviously the legal updates and the social media. And I just wanted to foreshadow that before we finish up today, we would like to get a feel from the group as to, do you support pay transparency? That's helpful information for us to understand what our members are thinking and feeling about these sorts of things. And we'll also briefly talk about the next legislation briefing as well. So, Jill, that's all that I wanted to say about that. I did want to mention, though, something, and this just reflects my generation. I wasn't aware that there are these sites on the internet called Glassdoor and PayScale where employees essentially are sharing information already about what applies to their jobs and their occupations and all the rest. So, the younger generation is already there and doing these active things. And I think we need to get on board speaking to those of my generation.
Oh, yes. Yeah. We've got the second poll up there about, given what we've discussed today, do you support pay transparency? If people would like to indicate their support or not for pay transparency. Now, Mandy's advising us we've had a massive response, which is good. I just don't know what that response is as yet.
It's very strongly in favour. There's 2% who don't, and I'd be really
fantastic. Thank you so much. Thanks, Mandy. We've got Mandy Gervin, who's a senior comms officer in PA, who's working really hard behind the scenes. So thank you, Mandy. 97% support us having pay transparency, which is fantastic. So thank you, everyone. Just a few more questions. And I think this goes to, and I think this is a really important one for a lot of people, is would the pay transparency now apply to performance pay? Because you've got your overall remuneration, but then of course in many organisations there's a period of performance pay, and understanding who's received what in terms of performance pay. Does it also encompass that I could go and ask you, Lyndall, what you got during this particular round and find out whether you got more than me and if that was fair?
Yeah, it should, because that falls within your remuneration outcome. And so they've drafted this legislation to try and be broad and capture that remuneration outcome. Like, what are you actually taking home? What is your actual pay? And yeah, it will impact that. So you will be able to ask people about, well, what pay did you receive for this, for your remuneration, for your bonus, etc. So that sort of stuff will be covered by it. But yeah, it will be interesting to see. I'm very excited to see all of these once this sort of people start taking advantage of it a bit more and we start seeing some of this stuff happen, see some of these outcomes from these transparent discussions that will happen. I think there's I think HR is going to have some very tough conversations ahead of them coming up.
Another interesting question that's come up around, what if you're in a company, so you're working in Australia and there's co-workers in another country, New Zealand, the US, whatever. Can you ask them what they're earning?
Look, I'll have to have a look and see what the definition of employee is under the Act. My guess is that it may not cover, you may not be protected by asking those if they're not considered national system employees under the Fair Work Act. So my recommendation would be don't do that at the moment. It's something I need to take on notice to do a bit more work in, do a bit more research into, but we can definitely, that's a good question. I'll follow up and double check that because yeah, I would like to make sure, because it does say employee, but that presumes coverage of the Act, and I want to make sure that whatever advice we're giving people, making sure that they're protected.
Yeah, thanks, Lyndall, because we actually do have a lot of members, of course, who do work for multinationals and international companies, so we want to make sure we get that sorted. The other interesting question was around those people who don't live in Victoria and don't work in Victoria. We're all covered by the Fair Work Act, but what about in other states? If you're covered by a state award, does this legislation also apply to you, or are you not covered?
Once again, not covered. So if you're in the federal system, you are covered. If you are not in the federal system, you are not covered. And once again, I would assume, and this is where I just want to do some double checking in terms of employees. as to whether asking people who are asking employees who are in other company who are working outside of the federal system. That's another thing I think I'll take on notice, and I just want to go back through and look at the meaning of the word employee in this particular section, because my initial reaction is that they wouldn't be, because they're not national system employees, they're not going to be covered, and therefore you wouldn't be protected if you asked them.
The other question that I think there's a lot of questions about what constitutes contract variation, and I presume your response is going to be the same, Lyndall and Margaret there.
Response.
Yeah, it will depend on what your contract says originally. So for those people who are asking, what if my pay changes? Does that mean my contract's varied and therefore the provisions will now apply to me? That will require a further consideration in light of your contract. The other issue that I'm interested in.
I will just say though, Jill, often you will have a look at your contracts. Often you will find clauses that say, if your pay changes, this does not affect the rest of the contract. In which case there's no variation to the contract. So have a look at that. Have a look at the wording of your contract. If it contains something like that, that's going to sort of give you an easy answer. Otherwise, yeah, it really does just depend on the wording of your contract as to what's going to constitute a variation.
So it's that same thing again. Someone's just talked about the fact that not only are there provisions within their contract about confidentiality of everything to do with the business, but what if you get a contract that says strictly private and confidential for the whole contract? But going forward, an employer wouldn't be allowed to do that in relation. So a new contract, you can't, the pay secrecy cannot be private and confidential. That's actually going to be illegal.
Exactly.
Yeah. And then what about employers that might not have it in your contract, but then it becomes a general policy? So your contract doesn't specify that you can't, that contract specifies you can't disclose, but there's or doesn't specify that you can't disclose, but the policy does, says no, you can't tell anyone what's going on.
Yeah, I saw this question come up and it's really interesting, especially, and once again, it will depend. And I think because a lot of contracts do contain you must comply with company policy, but my view would be that company policy isn't going to be valid if it's not in accordance with the law. It would be that would be unlawful policy. But it is one of those things that where that sort of happens, I'd encourage you to come to us. And that, because as I said, there's so many of these things, it will depend upon the particular circumstances as to whether you're able to use it. But where you have a company policy that's requiring pay secrecy, but you're required to comply with company policies, it does make it particularly problematic in terms of whether you are sort of subject to a pay secrecy clause. But also policies can be changed regularly, and it would be a difficult argument for an employer to rely upon a company policy in that respect. Very, very difficult, but I would want to look more into it.
I would just add, Lyndall, that it is the end of this is then the right to ask and the right to disclose is considered a workplace right. So to that extent, I'd certainly appreciate why you're being cautious, because I think it's got aspects about it. But if that were to come up where there were members in the workplace, my response would be, I think we should be writing to the employer about that company is really at best close to the wind, potentially illegal, would be the way I think as a union we would approach that on a collective level. Yeah. Yeah.
I think even on an individual level, if we became aware of that, that's something that we'd be looking at. And if they were trying to, I think as I said, it's going to depend upon the particular circumstances, but if there are policies requiring pay secrecy, we would need to look at what your contract says and stuff as to whether you have access to the laws or not. But generally, if policies, and also it may come down to when the policy was made, when the policy was changed and stuff, whether the policy is incorporated into your contract or not is going to be another key part about this. If the policies are completely different, but you have a workplace right, as I said, this is why it's kind of it's difficult to give general statements because it's going to depend on a multitude of different factors as to whether you have access to this right. But generally, it's if your employer is doing stuff to try and promote pay secrecy in policies, let us know. Let us know. As your union, we want to know, because we want to be able to go to that. We want to be able to use our collective force, which is why you're all union members, because you see the value in a collective and you see the value in that. And we want to be able to use that to go to employers to say, get rid of this. This is not in step with what society expects, nor the law.
Okay, so just one last question that I'm going to ask, Lyndall, that someone has asked us around. Obviously, people will be looking to us for looking at their contracts, right? So there's a question there around times for contract reviews.
Yeah, so what we do, we've recently changed our contract reviews system. And so if you do have a new contract, we're happy to review them. What we do is we sit down, you get access to 2 of the industrial officers. So it'll be a senior industrial officer or myself and another industrial officer. And we sit down and go through that contract with you in an hour period. We'll go through it clause by clause. That may not be what you're after. If you're just after an analysis of whether you have a pay secrecy clause, that can be something we can do that differently. And that wouldn't need to be that amount of time. We can do that, and we can provide you potentially written advice in respect of that sort of isolated question. So you wouldn't have to sit down with us for the full hour. But as I said, in that process, more than happy to go through and have like verbal chats with people about it as well. But if it's just isolated to that particular thing that you're after, don't feel you have to submit a contract review. Just contact the Workplace Advice and Support team and let them know that you want to pay secrecy analysis, and we can have a look and see what we've got and see whether we think you're subject to a pay secrecy clause.
Thank you so much. And again, thanks to Mandy for putting up the contact number for our Workplace Advice and Support team. So thank you. We are at 1:28, so we've got literally 2 minutes. So I do actually want to wrap up now, and thank you all for participating today. Big thank you to Margaret Buchanan and Linda Lablett. I'm sure you can see that they're both really well informed in terms of all employment matters, and are going to be particularly looking at this issue in the future. And one last thing, we actually do have another webinar in our IR reform series coming up, and that's going to be on International Women's Day, and it's around all of the provisions in the IR reforms that are about promoting gender equality. So looking at those issues around access to family-friendly provisions, rights to request, and have requests for flexibility responded to, etc. So that's going to be another really informative session. So I'd encourage you, when you see us advertising that, to register for that one. And thank you everyone for your time today. We look forward to seeing you again in the future. Thank you.